We're waiting for just a few more folks, but I think we're going to get started. I want to welcome everyone that is in this room joining us for this exciting discussion today. My name is Toni Morgan. I am the Managing Director at the Center for Law, Intervention, and Creativity at Northeastern University School of Law in Boston, Massachusetts. And as some of you heard earlier, Zoom makes it possible for all of us to join and participate in these events and be responsive to kind of some of the things that are happening in our world and convene and have a conversation about it over Zoom. So thank you for joining us. I want to say that this event was an immediate response to what we were seeing happening with TOCK and the executive order, and CLIC reached out to our student IP and privacy tech groups to see if they were interested in collaborating. So I want to also just give a quick shout out to the Intellectual Property Society at Northeastern, and as well as the Privacy and Tech NUSL group, who are co-sponsors of this event. Ramzi, if you can just say hello to everyone and let folks know what IPS is, that would be great.
Yes, thank you, Toni. Sorry if there's a little bit of trouble hearing me. The microphone on this laptop is a little bit low for some reason, but thank you, Professor, for joining us. We're really excited to have you guys here. And the Intellectual Property Society is co-chaired by me and another student, Evan, who I think has a class today during this time. But our work is trying to get students excited about intellectual property, but I mean, generally the students coming to the IPS are already excited about it. But what we're aiming to do is get the students to understand all the different avenues, because sometimes when people think about intellectual property, they only think about one certain field or one certain path, and we're trying to get people to understand that it's not just one, and it's not just the four, but it's many different types. So that's what our goal is.
Great. And then do we have someone in the room from the NUSL Privacy Tech Group?
Yes, I'm here.
Oh, wait, there you are.
Hi.
Hi.
So the Privacy and Tech Group at NUSL, we basically just try to bring together students, scholars, and professionals that are interested in the intersection between privacy, technology, and the law. And since NUSL has been a growing hub at that intersection, we've just tried to create a space that fosters student involvement and connections to that community of privacy and technology experts. So, thanks.
Great. So that is our small but mighty IP tech community. I'm going to turn it over to CLIC's faculty director, Jessica Silby, who will take it over from here.
Okay, thanks, Toni, and thanks to the students for instigating this very important and what I expect will be very interesting conversation with two of my good friends, I'm very proud to say, and really preeminent internet law and IP scholars. So I'm just going to make a very quick introduction. I've pasted their faculty bios into the links to their faculty bios in the chat, so everyone can look at that at their leisure. And I really think that Professor Chander and Goldman have a lot to talk about, so I'm not going to spend too much time, but I'm just going to highlight a couple things. So Professor Anupam Chander teaches at Georgetown Law Center. Before that, he was the Martin Luther King Jr. Professor of Law at UC Davis, where he was there for quite a while as well. He's the author of a phenomenal book, which I would recommend to all of you, called The Electronic Silk Road: How the Web Binds the World in Commerce, and among many other publications. He's a IP, internet law, international law scholar, and he writes recently a lot about privacy, most recently a paper coming out with Margot Kaminsky and Bill McGevern, if the privacy folks know those names, called Catalyzing Privacy Law, coming out in Minnesota Law Review. Also, I read an earlier draft of that piece some months back, very exciting. So that's Professor Chander, and he's gonna go first. Professor, oh, somebody needs to mute, maybe Rhonda. All right. Eric Goldman, Professor Eric Goldman teaches at Santa Clara University School of Law, where he also directs the High Tech Law Institute and supervises the privacy law certificates. So for our students, he's the Woody Hartzog of Santa Clara. Although he doesn't like autumn the way Professor Hartzog does, Eric is a Californian through and through. And he has two case books that are worth noting that have become foundational in the field: an internet law case book and an advertising law case book that if you take either of those classes, I feel sure there's a 50% chance you'll be studying from him. He has a recent paper that I commend to you, Emojis and the Law. It is important and fun to read as well. And he is known for sort of carving the cutting edge of internet law, and that paper is exemplary of that. As I see, it's our dear colleagues in the field, brilliant people, and I very much look forward to hearing the debate about TikTok, privacy, and the First Amendment. All right.
Great. Thanks so much, Jessica. I really appreciate that incredible introduction. And it's such a delight to meet the students. Ramsey and Meg, I was impressed with your descriptions of your for your goals and hopes for the year and the ambitions of your groups. So let me share a few slides. So I first wanted to kind of level set by describing where we were this summer and how we got here. So let's just do a quick TikTok on TikTok. Okay, so on July 31, in the evening on Air Force One, President Trump declares a ban on TikTok. Okay, caught a lot of people by surprise, and ran the news cycle. A week later, the president issues an executive order banning transactions with TikTok's parent company, ByteDance. TikTok is a California corporation, the successor to another company called Musical.ly, also another California corporation that was owned by a different Chinese company. There is a separate order for WeChat and Tencent as well. So WeChat and Tencent, which hadn't been signaled previously, are now added, have separate bans attached to them. Both of them basically say, if you do any transactions with these companies after 45 days from today, you are in violation of economic sanctions, okay? Which is something that no company wants to be involved in. So if you're subject to the jurisdiction of the United States and you do a transaction with these companies after sometime in September, you'll be in violation of these sanctions, effectively ending their ability to operate in the United States. Then on August 14th, he issues a separate executive order with respect to TikTok, ordering divestiture within 90 days. As I said, ByteDance had taken over Musical.ly a couple of years ago, and all foreign investments into the United States are subject to review for national security by the secretive committee called CFIUS. And he issued an order basically saying that also will require ByteDance to sell its ownership of TikTok to some other company. And then we see the litigation. And so TikTok originally files a lawsuit in California, in the Central District of California, which is, as I said, it's a California corporation. It's based in LA. So TikTok, but then for whatever reason, I think kind of bad decision-making by the client, TikTok, most likely, it withdraws that claim. a week or so later, refiles in the DC District Court. By this time, there's a separate case going on, which is WeChat users. And the WeChat users have filed, who are named plaintiffs in this case. So they describe, so each of them submits an affidavit about how they use TikTok and what the negative impact will be if they are, if this executive order is allowed to stand. So on the 19th of September, which is a Saturday evening, before a midnight ban goes into effect on Sunday, the Northern District Court, Northern District of California District Court enjoins that executive order against WeChat. So many of you are probably familiar with these two apps, but WeChat is largely an app used by the Chinese people in China and also by the Chinese diaspora, and anyone who wants to kind of have social network relations or other business transactions with Chinese people, because this is the dominant app in China. And so the Northern District of California District Court, after these kind of Saturday morning hearings, sorry, there's another person. If you could mute yourselves, that would be great. So after this hearing issues this ruling on Saturday evening, and Eric is going to describe these cases a little bit more. And then on the 27th of September, the next weekend, sorry, the dates seem, okay. The next weekend, the DC District Court enjoins the TikTok case in DC. That is, enjoins the sanctions against TikTok. Again, these are the IEEPA sanctions, not the CFIUS sanctions, which still are scheduled to come into effect in November, as it turns out. Now, that case is interesting because the government submits secret evidence in that latter case. It files a brief that is redacted, a redacted version of it, which is made public, I should say. But the secret evidence is provided to the district judge. And the district judge, despite that secret evidence, enjoins the order against TikTok, allowing TikTok additional breathing room for the next month or so. Okay, so that's kind of the official story that we might just quickly see. But actually, if we pull back the lens a little bit further, and Eric is a master photographer, and I could open up the aperture a little further, perhaps. Is that right, Eric? We might have a slightly different view of these scenarios. So what happened on July 31st? So on July 31st, the US economy posted its worst GDP drop ever on record. The United States had just suffered its deepest recessionary quarter on record in its recorded history. And the president chose that evening to pull out this TikTok ban, okay? So, which came out of the blue. As far as TikTok is concerned, we're banning them from the United States. Okay. And we can pull back the aperture, open up the aperture even further. Again, Eric, if you can correct me if my photography metaphor is awry. Go back to June. TikTok teens and K-pop stans say they sank Trump rally. Okay, so, and Trump said, I have the best words, now they're hers. Sarah Cooper, who is the brilliant comedian, former Googler, by the way, interesting to note. And she, by the way, we have her book, which just happens to be sitting here, just randomly. This is just pure hilarity, so I recommend it to anyone if you don't have this. So we had seen her caricature Trump kind of mercilessly, simply with his own words, just repeating his words and mouthing them, using the lip sync function on TikTok. She turned out to be far cleverer than any Saturday night skit over the last 4 years in skewering the president. So one of the weird things to note about TikTok is it's the one massive American social media enterprise that Trump hasn't mastered. Okay, think about YouTube. The level Woody's here, so we can. Should we deny him? Sorry. I have host privileges on this call, which is kind of interesting. Hey, Woody. Think about, YouTube, we know it has been, exploited by many of his fans. Think about Facebook, which we know has bent over backwards repeatedly to please the president. And think about Twitter, where he has a massive fan base and sends out tweets at 4 a.m. in the middle of the night from Walter Reed Hospital, shouting at us. So all those platforms are ones that he is incredibly skilled at. He or his followers are incredibly skilled at. But TikTok, which during the course of this actually said, we have plenty of Trump supporters on our platform. Okay, just imagine that as your legal defense. Okay, so they, TikTok, we know, has been used repeatedly to humiliate the president. And with Sarah Cooper, near daily humiliations of the president. And so here's a broader TikTok on TikTok. Sarah Cooper, we'll just put her at May. Tulsa rally foiled by TikTok teens and K-pop stans who quote, purchase or reserve tickets to Trump Tulsa rally, causing Trump and his campaign manager, Brad Parscale, now further infamous, to boast that they have 1 million people who've signed up for their rally, when the rally turned out to be very poorly attended, which would make sense because we're in the middle of a pandemic. I'm not saying he doesn't have lots of fans, he certainly does. But even his fans diminished somewhat in the course of a pandemic in their desire to show up. And then, of course, there's something weird that's happening, something important that's happening at the end of this period on November 3rd. And so all of that has to be seen as the relevant context. Okay, so in general, I know that many of you will be asking about the national security implications, et cetera. I just want to really kind of implore you to think about the critical role of the press and social media of election in the context of where that social media has turned out to be a thorn in the side of the government. And the analogy I like to use is consider this. Consider a TV station or a newspaper in a foreign country. Let's imagine in a third world country, which 3 months before the election, the president declares a vessel for foreign influence in the country, and then shutters it. And that newspaper or TV station had proven to be very popular with the critics of that president. We would all decry that as an authoritarian move. And I don't think we can conclude readily that this is a genuine national emergency occurring just prior to the election. There's a lot of this that really should raise our eyebrows. And I think you've seen here 2 district judges, both reviewing the evidence. And despite claims of national security, insisting on judicial review and insisting that the plaintiffs in both those cases had a likelihood of success on the merits. And in the latter case, in the face of all the secret evidence that the Trump administration could muster, and in the latter case, with a judge who was appointed by Donald Trump, a judge who was a longtime member of the Federalist Society. So I think we should wonder what that secret evidence is, and we should speak up, because we should not allow for creeping authoritarianism in the United States. At least this serves as a terrible precedent for the rest of the world, and our own kind of great firewall now against China is something that we should be cautious about. And I'm going to turn it over to Eric to pick up.
Thank you, and I'm so delighted to be here. This is a great honor for me to share the stage with Professor Chander, and of course with Professor Silby and with Tony. Professor Silby did mention that we recently co-authored an article together, which was one of the great professional highlights of my last couple of years. So just super flattered to be here. And I thought Professor Chander did a great job of laying out the general foundation of both the case, but also the motivating impetus for the government's action. And what I'm going to do, I'm going to say a few words about the case, but mostly I'm just going to tell you why I'm so upset. And I'm a blogger, so I usually have sharp words, but this time my words will be more angry than sharp. It's a little bit unusual for me, but what's happening here really is the worst of kind of government conduct that we can imagine. And so I'm delighted we have a chance to shine a spotlight on it, but it brings me no joy to do that, because what's going on here is deeply wrong. As Professor Chander mentioned, 2 different courts have evaluated the evidence that the government's marshaled to justify the shutdowns of TikTok and WeChat. The courts both reached the same conclusion, that the order was should be enjoined, but they reached it for different reasons. In the case of the WeChat ruling, the court relied on the First Amendment and said that it was an unconstitutional restriction on speech. In the case of the TikTok order, the court said that it failed to meet the elements of the statute. So the statute that authorizes the president to engage in an executive order on an emergency basis, the court said that the government didn't provide the proper evidence of that to support that on a statutory basis. Those decisions are actually mutually reinforcing. Now, it means for either of the 2 cases to proceed, we know that that the government's going to have to overcome both the statutory requirements and the constitutional challenge. So I think the government is going to have a really tough time successfully proceeding here. Of course, they'll still try. This is, as Professor Chander mentioned, this will be an ongoing issue through at least the election for reasons that have nothing to do with the merits of the case. But the government has a really uphill battle. One thing I do want to note here is that if you go back to the timeline that Professor Chander laid out, you'll notice that there was basically this 45-day roll-in period. But the actual specifics of the order just came out a couple of days before that deadline. And so what that did is it created this rush basis for the plaintiffs in these cases, the people challenging the orders, to challenge them in court, because they couldn't challenge this abstract order. They needed the specifics. And then once they got the specifics, there was literally just a couple of days before the bans were to go into effect. So a shout out to the judges in both chambers in these 2 cases, who basically, as Professor Chander mentioned, worked over the weekend to crank out what I consider to be very sturdy opinions. But they're not the kind of robust opinions we'd expect from a more leisurely litigated case where the parties have a full chance to present all their evidence and the judge has a reasonable time period to actually digest it and write an opinion. So I don't want to focus so much on the merits of the opinion per se, only because they were a rush job. And they were a rush job because the government, I think, in my opinion, deliberately delayed the details to make it extremely hard to challenge the order. What I'm going to do is just recap one thing that Professor Chander mentioned, then tell you why I'm angry. And I'm sorry to talk angry here, but I got to be honest with my emotions. I want to come back to this notion about national security. The national security interests here have always been pretextual. It's not even really a close question. What you're seeing is that in order for the government or for the executive branch to have the authorization to take advantage of this very powerful statute that gives emergency powers to the president, they have to have a justification like national security. So what they do is they say, there's a national security concern here. And when the government tells us that there's a national security concern, our ears normally would perk up and we'd say, oh, well, this sounds serious. This is something we shouldn't be worried about. But notice that in this case, it's always been a lie. It is the basis on which they can take advantage of this power, not because there's actually a national security concern. It's purely the veneer of the rule of law. It's a way of lying to the American people by adopting the legal tools that have been put in place to give the president's authorization, but there's never any substance behind it. And what it does, and Professor Chander was hinting this, so I'm gonna hit it right on the head, is that it spins up the media to report this as if there's a legitimate national security concern here. And then we all respond accordingly to that, like, this is a legitimate proceeding, that the government is doing something legitimate and the courts are going to legitimately evaluate it. But because the fact that it's always been based on a lie, what we're doing is we're fighting the lie as opposed to actually working towards doing something that's beneficial. I'll come back to that. So, so whatever you hear about national security, and Professor Chander, I don't know if you're going to get to the other slides that you have, but Professor Chander actually can pull apart the reasons why national security arguments have never been credible. But think about them not as the government trying to do the best for the American people. Think about the government just looking for an excuse to take advantage of this very powerful tool that Congress gave it, and then lying in order to look like they're checking off the rule of law. Okay, why am I so angry? I mean, that would have counted, but let me go on to the two main reasons why I'm really angry here. One is this is just flat out censorship. You can call it whatever you want. You can try and guss it up into some kind of legitimate rule of law activity. This is censorship. What the government's trying to do is to shut down a tool that's being used for socially legitimate and constitutionally protected speech. There's no question about the collateral damage of shutting down TikTok or WeChat. The consequences are that constitutionally protected speech will be eliminated. And we might actually think that's the government's goal. That's not some kind of side benefit. That may actually be the intent and desired outcome of this effort. So whenever I hear things like there's an executive order to protect national security, what I'm hearing here is there's an attempt to censor a speech venue that is absolutely the kind of thing we know you can't do. And it's so clearly beyond the scope of what the government can do. And Professor Chander hinted at this as well. Again, I'm going to pull it out really expressly. If they get away with this, then they're coming for other social media as well. There's no reason then to stop to think, oh, well, they'll only invoke national security when it comes to the Chinese sites. No, they'll invoke it against any site that they want to shut down. And as we know, the government tends to prefer more censorship over less. They'll look for ways to shut down conversations they don't like. So everything here is like a preview of what the next stage will look like. If they get away with this, they'll do the next step, one step further beyond, and so on, until we get to the point where we reach this crazy outcome that the government can censor speech venues whenever they want. We know that can't be the deal. That's the way we were brought up. We know that's what the Constitution says, and yet they're trying to do it anyway. That makes me angry. The other reason why I'm angry is that I don't understand how this benefits the American people. As Professor Chander indicated, this really is just a play to dominate news cycles before the election. But let's put that aside for a moment and just say, okay, can we find any basis on which this will make the American people better? And I come up completely dry. I can't think of any rationale that shutting down TikTok or WeChat will actually help the American people. They're taking away our tools to talk to each other. That alone is a net negative for our society. And so what we're having to do is we're taking our resources, all the time and energy that's being spent in this conversation and all the other conversations, and we're just fighting to preserve the status quo. We're just trying to get back to where we were before Trump had his tantrum. And so that kind of effort, it makes us poorer. We're spending time to just fight for our rights as opposed to actually being able to build something new. And as Professor Chander mentioned, we've got big problems in our society. He mentioned the economy as one possible basis on which Trump wanted to overcome the news cycle. But we've got a pandemic, we've got an election, we've got rampant violations of the rule of law taking place in our society. We've got racial justice problems in our country, and so many more. These are what we should be working on, and we're not. And our government is taking the resources, our taxpayer dollars, to spend it on fighting to preserve this order and not working on those things that are existential threats to our country. And it also doesn't make us a great country because it actually works against the narrative that we've been fighting for decades. We have been viewed as the country that's trying to export free speech norms. We're trying to teach the rest of the world that they can benefit and flourish if they adopt more free speech. And this actually has been a great way of teaching the rest of the world how to actually deploy a censorial legal tool. You come up with a combination of national security rationales and set up a Fortress USA. These are things that repressive regimes are very interested in, and we're showing them how to use the, quote, rule of law to make it look legit in order for them to replicate it. So we're exporting censorial norms as opposed to free speech norms. This is not making America great. The last thing I'm going to say is that, and this, Professor Stilley was so kind when she said that I was the Woody Hartog of Santa Clara University. That is the nicest compliment I'm going to get this week. But Professor Hartog and I don't agree on some of the normative issues here. I view many of the efforts to try and improve or increase privacy as actually a backdoor mechanism for censorship. And that's what's taking place here. The concern is that data is flowing out of the United States into the hands of the Chinese government. So the solution is to use a privacy-style regulation to try and keep that data from flowing into the hands of the government. Now, I think that's great. I think that we should be very concerned about our information going into the hands of any government. So I support that general concern. But what happens here is that we can then use that debate and say, in order to stop the flow of information, we're going to stop the flow of speech. And so this privacy justification as a way to create a rationale for censorship is something that we're seeing taking place across the globe. And across the globe in particular, there's been a number of efforts towards what's called data localization, where government says, we don't trust the rest of the world to manage our citizens' data properly. So we're going to force that data to stay within our country. That's exactly what actually the US government's trying to do with the TikTok and WeChat orders. They're trying to keep that data within the United States. And then what the governments then do is once they're able to control that data within the United States, that becomes the basis for them to impose censorial regulations on all the data possessors. Whoever has that data, then they can say, now that you've got this data local, we're going to tell you what you can do with it. And so by keeping it local, it actually gives more power over the government to control how that data is used in free speech and anti-government purposes. And that's exactly the kind of thing that the government's trying to do here. In general, we should be nervous whenever we see the erection of borders on the internet. That's often not designed to be in the benefit of any user. But when the justification is privacy for the right to do that, it's actually showing that we want privacy, but we actually don't want to sacrifice these other values, and governments are putting them in tension with each other.
Great, Eric. I might pick up a little bit and return to the security rationales. So, and I'm not going to try to canvass them fully, but I just want to make a couple quick observations, and I'll share my screen again to do that. Oh, sorry, if you could, Tony, yeah, sorry. Great. So the essential security claims are twofold. China could siphon data from US persons developing profiles, and China could steer TikTok's algorithm to prefer its own worldview, right? And both of those are serious concerns, and I don't mean to dismiss them. So we could call the first blackmail, and the second brainwashing. And so those are the security arguments that I think are offered by the U.S. government and by critics here. So with respect to the blackmail, I'd like to note that there was an earlier purchase of an American social media app, Grindr, by a Chinese company, Kunlun. And when CFIUS, that Committee on Foreign Investment in the United States, reviewed that investment and decided on national security grounds to bar it, it gave Kunlun more than a year to divest itself. And this is 2018 to 2019, so this isn't a long time ago. And so there was something really odd about TikTok being given 45 days or 90 days, depending on which order you look at, to divest itself. When you consider Grindr and TikTok and their different information bases that they have, Grindr was literally an app about private dating, and TikTok is largely an app about public dancing. And so one clearly has far more significant kind of blackmail possibilities than the other. And so people could be married and be dating privately. Most of that behavior would be private, not for public consumption, whereas most of the behavior on TikTok is largely for public consumption, including, for example, Claudia Conway's recent public statements, which, you know, it's hard to imagine what exactly that kind of activity is reveals to China more than to Americans or something along those lines. Okay, so the second is China could steer TikTok's algorithm to prefer its own worldview and brainwashing. And let me focus on this in a slightly different way. I want to talk about the TikTok clipboard. Okay, so for a long time, when you hear about TikTok, you'll hear about TikTok's activity with respect to the clipboard. It turns out that iOS 13 had this feature that allowed any app to grab what's on the clipboard and do it with great frequency without and needing any special permissions granted to that app. And so what you see is literally hundreds and hundreds of news stories about TikTok and its clipboard activities. And so unfortunately, you know, so the tons and tons of news stories reporting on TikTok's kind of problematic behavior with respect to the clipboard. Well, it turned out that that was really just very much only a kind of narrow version of the story. And so here's more, you know, so any case, it turned out that this was that the security researchers who discovered this said this is being done by tons and tons and tons of apps. Okay, let's just go to the column on the right. ABC News, Al Jazeera English, CBC, the Canadians are doing it, okay, CNBC, Fox News, Newsbreak, New York Times, National Public Radio is still doing it, NTV, Reuters is still doing it, Russia Today, well, that's not surprising, Stern, Nachrichten, German paper, I presume, but I'm not exactly sure, The Economist, Huffington Post, Wall Street Journal, Vice News. All of these apps are doing the same thing. And TikTok explained that this was an anti-spam feature, and it quickly disabled it once these security researchers pointed this out. Certainly, rampant copying of the clipboard could be used for snooping. I don't doubt that that possibility exists. But targeting TikTok as a particularly malevolent actor in this space, and this being evidence of their malevolence, their malevolent design, was really quite stunning. And it's stunning to me how the news media repeats objection again, again, and again. Strike. I've never seen that clipboard objection in the New York Times, because I think the New York Times reporters realized, oh shit, we're doing it ourselves. So it's hard for us to complain about TikTok as this great threat, security threat. So none of this is to say that we shouldn't be concerned. Certainly TikTok is was censoring things earlier on to favor Chinese government line. And I think TikTok has rapidly changed its policies. That kind of content moderation question is one that you've seen all the media companies being guilty of behavior that they really should realize was unacceptable. I think that is exactly the way we should approach these things, and hold them to account. But I think this kind of ban is as Eric said, it really makes us borrow China's approach to the internet, and I think will stand as a terrible precedent for the future. I'll stop there, and I'd be happy to turn the floor back to you, Jessica.
Great. Eric, did you want to add anything else before I have a couple questions in the chat? No?
I already melted my microphone down, so I'm not sure how much more I can add.
No, I'm sure. I do have a question that was asked to me over chat, which I will ask of both of you. I'm going to add to it a question of historical perspective as well. And just for the students on the call, the idea that the government, the federal government, is trying to pick winners and losers in the public arena of speech, like they, like Facebook, don't like TikTok, or like people on Facebook and Twitter and not on TikTok, is a quintessential problem for First Amendment. It's one of the things that the First Amendment law since the beginning has tried to fight against. That is, the government shouldn't be picking winners or losers. Eric called it censorship, which that's what it was called. But the government has done that for a very long time. That is, we have been fighting this battle about government picking winners and losers over centuries. And so there is one of the things I would love to hear from Professors Chander and Goldman is to contextualize this in maybe the context of the McCarthy era, for example, or the Sedition Acts at the time of the founding. That is, how bad is this? Does the internet make it predominantly very different? Is it a different paradigm? Because we have seen this before. So that's one idea to bounce around. And from a participant, specific and helpful questions about what is the relevance of if the media organizations are acquired by U.S. companies, how does that change? How does that change the case and the legality of U.S. government intervening? And also, what do you predict the outcome of the cases are going to be? That's a little bit of fortune telling, but maybe you can be informed by the history on that one as well. Okay, and Woody will have a question after that.
Jessica, I might take up your first question, and I'm sorry I missed your second question because of internet troubles. I think your reference to the McCarthy era is an important one. And I have a piece up in Wired talking about an earlier scare of communist infiltration in the United States. So in the middle of the last century, this was quite the norm. We did want to censor speech coming from the communist countries. And so we had, so Claudia will remember this case called Lamont v. Postmaster General. It's just a fascinating case. So there's a statute passed at the beginning of the 60s, of all things, that said mail from communist countries, essentially, that might have communist propaganda had to be held by the postmaster. And then if you wanted to receive it, they'd send you a little note saying, hey, we got this communist mail for you. Do you want it? And then they would develop a little list of people who wanted this, the communist mail. Literally, I mean, they were keeping lists of people who wanted communist mail. And this goes up to the Supreme Court, and 9-0, the court has no problem saying that is unconstitutional. And so there's something there about the right to even get communist information. That was pure communist propaganda, by the way. It wasn't coming from the Soviet Union, which is my recollection of the case. Was that it was coming from the Soviet Union. But when you go back and read it, which I did, a couple weeks ago, it was coming from Beijing. It was called the Peking Review number 12. That was the issue that was that Lamont had wanted. And so I think the Supreme Court, the Supreme Court had really understood that free speech even involves this kind of speech that the U.S. government may disfavor being received from abroad.
Eric, do you want to say anything about the corporate holding being foreign versus U.S. as relevant or not relevant to the outcome of the case?
Yeah, a couple of thoughts about that. So in general, my head is at, I don't really think that the government should be in the business of deciding which speech venues are legitimate based on where they came from. In other words, I don't have a problem with Russia Today publishing in the United States. I don't personally read it, and I don't consider it credible, but I would be troubled if the government decided to just shut it down and say that point of view is no longer welcome in our country. So the idea that TikTok and WeChat are owned by the Chinese government in part or in whole really doesn't change the sensorial nature of what the government's trying to do. So to me, I would view that as fundamentally irrelevant. But the fact that the government was trying to push TikTok's ownership into U.S. hands creates its own set of really awful dynamics. And again, it shows how the rule of law is being weaponized against the American people rather than actually protecting us. So as far as I can tell, this is my impression, I'm stitching together a bunch of details, which you may or may not agree with. The point of the TikTok ban in part was to suppress the valuation of TikTok. It made the assets less valuable, which made it more attractive for American investors to acquire an interest in it. Basically, like either you get kicked out or you get bought by an American company. Well, guess what? The American companies can now bid less for the same assets because they know that there's this fuse in TikTok's time horizon in the US. And so when it emerged that a combination of Oracle and Walmart were going to be taking a partial interest in a new entity that was going to be affiliated with the TikTok assets, it started to make me worried that in fact what happened wasn't some kind of beneficial transfer of power away from the Chinese government into the hands of trusty Americans. It actually was all a corrupt game that was designed to depress the valuation of the assets and then provide those assets at a discounted fire sale price to people who were loyal to the administration. There are very deep ties between Oracle and the Trump administration. And so one way of spinning the facts is that actually the entire payoff here was to let Oracle get a piece of TikTok at a discounted price thanks to the government intervention. If that were the case of fact, that would be the worst kind of behavior, not the best.
Anupam?
So I wanted to pick up on that because it's so critical. So Oracle's, why is it Oracle? Okay, right? Weird, kind of. And so it seems likely that Oracle is there because it has the closest relationship to Donald Trump, right? And that's why TikTok, which desperately wants to survive in the United States, is trying to figure out how to navigate this mess. And it's choosing a suitor who it thinks will please the parents. It'll please Donald Trump because Oracle's folk have hosted fundraisers for him. They're there for him at every turn, and they're clearly supporters. And so, by the way, I heard Eric Schmidt talking last week, and it turned out that where is TikTok's data being stored now? It's being stored on Google servers in the United States. So what this is doing is moving it from Google servers to Oracle servers. Why is Oracle interested? One, it's a great asset that you can buy at a fire sale price. Two, because Oracle wants to grow its cloud business, and TikTok is an amazing cloud customer to have, right? Enormously impressive cloud customer to have. And this moves the cloud business from Google to TikTok, from Google to Oracle. But furthermore, it puts an Oracle person on that board, okay? So it puts an Oracle people on the board. And that's also critical because if you're thinking about content moderation right before the election, so this is about job owning. This is about, using the tools of government to make sure that TikTok tries to please the feds and tries to please Donald Trump. And how better to please Donald Trump than to put one of their people, one of Donald Trump's supporters, in the boardroom for TikTok.
So you've just described two fronts on which the Trump administration is trying to control speech. One through the courts and through these executive orders, and another through corporate control. And close relations like that. That is, I have to say, like, I'm wondering, where's Trump going to get all his money when he doesn't win the election and is in $421 million in debt? You got to wonder what's connected there as well. That's truly terrifying. All right, Woody has a question.
Yeah, hey everybody, it's great to see you all. Thank you so much, by the way, Anupam and Eric, for joining us here. I really always appreciate your perspectives, and this is no exception. I had two questions. One was about jurisdiction, while I have some experts on jurisdictional issues, and the other one was on data localization, which Eric brought up. The first question I had was, I'm legitimately curious as to whether, I take the point that a lot of this, there's a lot of ulterior motives behind this. But I wonder if Anupam, your distinction between blackmail and manipulation as being the two major concerns, I think was a really elegant way of summarizing that. And it made me wonder, jurisdictionally speaking, if we passed a law that got at algorithmic accountability, for example, that some of the concerns that we might have about TikTok, putting free speech questions aside, but just sort of general algorithmic accountability questions that would apply to TikTok as well as a lot of other companies. And if we, and if China wanted to get information on data that was held in the United States, are there any jurisdictional barriers that exist right now to that happening right now? So in other words, is the MLATS process sort of function, and I'm asking this legitimately, functioning well where the data is already flowing to China? And so maybe this concern is overblown, and the fact that we would have to resort to something as significant as this, instead of passing a general algorithmic accountability law that had jurisdictional reach to companies in other countries. So that's my one question, and it's literally just a sort of, how far can the U.S. go with other regulatory efforts here, and how much is this already an issue? And then the other question is unrelated, but since we have a little time, I'm going to ask it anyway, which is about data localization, which both of you have written about a fair bit and are really knowledgeable about. And Eric brought up the point that a lot of seemingly privacy issues are being leveraged really in service of other interests. And we saw this even with HIPAA, right? So HIPAA was thrown out yesterday as like, whoa, we can't tell you because of HIPAA, but that's not why the HIPAA was being invoked, right? And so it made me think about data localization, because in the discussions that we've had around, data has to be stored locally for privacy interest, it can feel a little protectionist, right? And that maybe there are some other motives behind data localization besides pure privacy interests. So I really just wanted to get both of your takes on data localization generally, and maybe for the benefit of the other audience, as to whether any of this actually serves privacy interests, and not just maybe in this particular debate, but then more broadly with Europe, for example, or if data localization is largely being used in service of other non-data protection or non-privacy related interests.
Who wants to take it first?
I'll do the first one, the jurisdictional question. So if the United States passed a Algorithmic Accountability Act and required some kind of procedures, transparency, et cetera, that would be applicable to a foreign company operating in the United States as well. The same is true, of course, as you know, Woody, of the GDPR. You know, if you're operating in Europe, wherever you're coming from, whether you're American or Chinese, you have to abide by European rules. If you're operating in California, whether you're a Californian or from New York or from Canada or China, you have to operate by the rules of the California privacy statute, the CCPA. And don't get, I don't want to make Eric explode if I say the CCPA here.
Oh, and also really quickly, Eric, do not check Twitter right now, whatever you do.
Wait, I already did it. I'm crying.
Okay. So I think there's no problem with jurisdiction. Here's the funny thing, though. You raised issues of MLATs and things like that, which I find, so there's this whole international corporate law stuff that's operating in this case.
Somebody has to say what an MLAT is.
Oh, sorry. The mutual legal assistance treaties that we have arranged bilaterally between various countries. Have a number of treaties are well understood to not be functioning well. The authority often like to this, very, you know, but one thing that I think has been bandied about without any kind of thoughtful intervention or review is this idea that China has a law, a national security law, that says, you know, you've got to provide information if you have that information. And that means that ByteDance, which is subject to that Chinese law, even though it's a Cayman Islands company, it must then be compelled to, will then compel that information to be exfiltrated from TikTok to China. That is a leap of international corporate law that doesn't really make sense. You know, so you can't, as the foreign entity, simply order the domestic company to violate domestic law, to violate California law or US federal law. That's just not the way that international law or corporate law works. And so there's just a kind of assumption in all the reporting that ByteDance at the flick of a hat can say, we want this data here, and the data arrives. If that happened, it would be a huge violation of American law. And so because, first of all, you know, TikTok has made all these statements about why that is impossible. And Woody, you've written important stuff on great stuff on the FTC, and you know exactly that would be lead to enormous class action damages, you know, class action suits and an FTC claim, and, you know, be ruinous for TikTok. And so it's just, you know, the kind of stuff that, you know, I think corporate law scholars would say that's just really not the way that the world works. And by the way, you know, we have the USA Cloud Act. We have a lot of things that are national security related, you know, obligations for our own companies. And does that mean that anytime that we tell Microsoft, grab that stuff from wherever it is, give it to me. And so all our data are the NSAs. You know, that it's the kind of shocking in the breadth of the claim that really doesn't reflect anything we know about interjurisdictional conflicts that can arise in these contexts.
Eric, do you want to say something about data localization?
Yeah, I do. Just a reminder, so data localization requirements require the data of a country's citizens to stay within the country, with the theory that if it's exported outside the country, either you have a jurisdictional problem enforcing any violations, or you're concerned that the country to where it's exported will not have equally protective provisions. And so by allowing the data leak out of the country, it goes into a country where it will be treated without the sufficient privacy protections that are necessary. And in some sense, you almost have to have a data localization requirement or some equivalent way of ensuring a minimum floor in other countries if you want to protect privacy. If you have this really fantastic privacy law that applies within country A, but countries B through Z don't honor it, once the data gets out into countries B through Z, then you've lost all the ability to control the data that you wanted for the citizens. So I understand why data localization is an integral package, a part of the package of privacy laws that you come up with. The problem is, and one of the things I hope that you've learned today, if you weren't already thinking about it, is about the way in which governments can engage in pretextual justification of their decision-making to make it sound like they're doing something that's in the citizens' interest, but really isn't. It's something that's adverse to citizens' interest. And the problem with the TikTok and WeChat executive order is it's filled with multiple layers of pretextual justification. So that's why it takes over an hour for Professor Chander and I to pull it apart and pull out all the different things that are going wrong here and say, and this was pretextual, and this was pretextual, this was pretextual. It's like a walking conglomeration of pretextual justifications. Data localization can be used for pretextual justifications as well. And I think that's the problem that I have, is that I often fear that the real justification isn't being disclosed to the public. It's not about protecting privacy, it's some other interest. I already mentioned one pretextual reason why you might adopt data localization. That would be something related to censorship, that by keeping the data in a country, you can control how people speak about the government or whatever the government wants to have discussed. Two other reasons why we might have it. Woody already mentioned one of them, this notion of protectionism, that it might be a way of bolstering a local economy and potentially suppressing activity outside of the country's economy. So, for example, in Russia, in order for you to comply with data localization operations, you have to basically invest in assets in Russia. You can't comply with it any other way. And so it's a way of basically moving more economic activity into the country, and by implication, not having it take place outside the country. One other way that data localization might be pretextual is it can also be a way for incumbents to suppress or hamper startups. So even within a country, if there's incumbents that have a better ability to bear the cost of localization, they might have an advantage over their local competition as well. So there's a bunch of other things that could be going on behind data localization besides what could be a very legitimate privacy interest. It's our job to ask those questions and get to the answers.
Thank you so much, both of you.
Yeah. So there's a question from Michael Gordon that says, I don't know, did we just lose Professor Chander? I think we might have just lost him. Courts typically give heavy deference to national security risks, even if they're pretextual. Yes, they do. That's Trump versus Hawaii, among other things. Korematsu also. Does the fact that the First Amendment concerns are at issue change the outcome here, or is it something else that led Magistrate Judge Beeler and Judge Nichols to grant preliminary injunctions against App Store removals? So that question is in the chat to everyone, so everyone should be able to see it.
So what I think just a quick point here. both the federal judges heard the issues, and they decided that there were different reasons. And so the second judge, Judge Nichols, said so he took the statutory authorization as the basis for his decision, but he said there were other, quote, serious questions raised by the plaintiffs. And there are a plethora of problems. And I think the First Amendment problem is really the most important, most grave, but there are due process concerns, there's takings concerns, and there's APA concerns, but really what we've seen. So I think it's important. I think it's critical. So one of the fundamental things I have been trying to argue is that national security is the basis for the rise of every authoritarian government that exists in the world. That authoritarian government is protecting you from something else. And that is, I mean, that's all of human history. Every authoritarian government relies upon a national security rationale. Okay, so we cannot, we can never, and I have, the level of anger, that I could muster on this, I'll say to the courts that the courts must defer to the government's declarations of national security whenever the government so declares. And we should be ever vigilant about this. We saw that with, the actions against communism in the 20th century, but all of human history. It's more important to look outside the United States even. Concerns about national security have driven, been the justifications for so much of.
I just want to add that I want to go back to what I said earlier about how, in some sense, the court's decisions in both TikTok and WeChat were really shining moments of the federal judiciary. That not only did they parse through this clearly pretextual national security justification, but they did so on an extraordinarily short timeline. We're talking a matter of a couple of days from filing to opinion. So I really feel like it's the federal courts that are protecting us and our country from what is an obviously abusive action by the government. So a shout out to the judges and their clerks and their staff, and to the constitutional framers who realized that we needed courts to be able to stand up to the executive branch.
That was a great question, Michael. Does anyone else have any other questions or thoughts they'd like to share? When Professor Chander started with the image of TikTok not being a digital platform that really melded with Donald Trump's way of communicating, I thought that was just perfect, right? The idea is that he wants to get rid of the platforms that don't amplify him, but amplify others. Something to be said about more platforms, the better then, I think, actually. That's what we say about speech also. Anybody else? This has been a fabulous conversation. I don't want to cut it short, but there's a world outside of Zoom.
And on that note, I'll just say thank you to everyone for joining us. We have recorded this event and we will certainly be posting it. And in the meantime, feel free to follow us on Twitter at CLIC. We regularly engage in these conversations at a number of levels, and we've got a number of really interesting and exciting events coming up. So I would encourage everyone to continue the conversation with us over the next, just continue the conversation with us. Have a really great week, everyone. Thank you to the IPS, Intellectual Property Society, and NUSL Privacy Tech Group for co-hosting this event with us. And we'll see you at the next one.